Ladies and gentlemen, welcome back. It's been a long time since I've seen you last, and this is, well, Samuel Adams Returns, but more of the echo chamber. And I've been calling it that, as you've been seeing it in the blog, the echo chamber. But one of the important aspects of today's program, and once again, we're keeping it in that format so that I can deliver it to Liberty Works Radio Network in 3 segments. Then I'll compile it all together for you and put this up on Rumble and on the website. So it'll get posted, maybe even on YouTube, probably. But what we have is, I told you so. I warned you. I gave you information as to what is going to be occurring and what is occurring right now. Very importantly, I'll just take it back just in a couple instances, is June 23rd, 2022. Courts and mental health industry destroying the republic. I have a list of all the different programs where I talk about Robert Yates and him in writing as Brutus in relationship to what the courts could become if we do not have a trusted, if we do not have a moral and virtuous people, if we do not have that stability in personage, then the courts of all things would become problematic. To the extent that we are really discussing what is happening with the presidency. And the presidency, we're understanding and seeing all of these craziness by the courts because the courts do not want to acknowledge foundational truths established where? From those that wrote, debated, commented on the Constitution. We know very succinctly, by virtue of what I like is the Founders' Constitution, that the presidency was designed as that independent component to execute the laws of the nation. And you can go through, which I can tell you as I keep watching and listening and reading what's going on with these liberal justices. No, they're not even liberal. They are, quite frankly, communist judges. These people are such ideologues that they're totalitarian in the very essence of their beings. And I'll touch on, in this segment, in a couple moments, about a secret society of the judges that we have even John Roberts a part of. So I posted up on Facebook that the idea that everybody keeps wondering, conservatives keep wondering, what's up with John Roberts? Well, just look at the article that I have for you in the notes at samueladamsreturns.net for this week's or this month's program. I'm only doing the programs monthly. And to help out, I am going to make that plea that a lot of others do, is that if there's ever any value that you receive in what I do, please take and click like, subscribe, all of the other things that are asked to do on all the other programming, because that's why I call this now the echo chamber, because a lot of it may be I'm just speaking to myself. But the content here is that historical perspective of truth as it relates to our present time. And in that context, when we start to look at the Founders' Constitution and that is there at the University of Chicago, has been developed, and I've shown you those books numerous times, and the link to these particular documents are available for you to review. I would definitely ask that you pay close attention and you go look for yourself. But let me start out with just some ideas from none other than Thomas Jefferson to John B. Colvin in relationship to Article 2, Section 3. And I know everybody's familiar with Article 2, Section 3, correct? Well, let me go back over here and let's see. Article 2, Section 3 is none other than, I thought I had it up for you right away. Article 2, Section 3 is he shall from time to time give to Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. This is the President. May, on extraordinary occasions, convene both houses of Congress, or either of them in the case of disagreement between them with respect to the time of adjournment. He may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed and shall commission all the officers of the United States. Very important right there, that last sentence, that last clause, if you will, phraseology, if you will, is that he shall take care that the laws be faithfully executed and shall commission all the officers of the United States. Now, what's interesting in respect to that is that Thomas Jefferson was writing a very unique letter, and what was going on at the time. There was a question that was proposed on whether the circumstances do not sometimes occur, which made it a duty in officers of high trust to assume authorities beyond the law. Is easy of solution in principle, but sometimes embarrassing in practice. A strict observance of the written laws is doubtless one of the high duties of a good citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger are of higher obligation. To lose our country by a scrupulous adherence to law would be to lose the law itself. Are you hearing that? With life, liberty, and property, and all those who are enjoying them with us, thus absurdly sacrificing the end to the means. When in the battle of Germantown, General Washington's army was annoyed from Chew's house, he did not hesitate to plant a cannon against it, although the property of a citizen. So he goes on talking about other besieges and then leveling other people's properties, and what he did and what George Washington did during the war to take and ensure the greater public safety. Ought the executive, in the case and with the foreknowledge, to have secured the good to his country and to have trusted to their justice for the transgression of law? I think he ought, and that the act would have been approved. After the affairs of Chesapeake, we thought war a very possible result. Our magazines were illy provided and some necessary articles, nor had any appropriations been made for their purchase. They ventured, however, to provide them and to place our country in safety, and stating the case to Congress, they sanctioned an act. There was an act that they did, and they sanctioned it. So you have to understand in what is going on in this letter from that historical perspective. So Jefferson kind of sums it up in here, and he talks about what was going on with Burr being crushed uh, down in Mississippi and what happened in that regard. So he goes on to say, from these examples and principles, you may see what I think on the question proposed. They do not go to the case of persons charged with petty duties, where consequences are trifling and time allowed for a legal course, nor to the authorize them to take such cases out of the written law. In these, the examples of overlapping the law is of greater evil than a strict adherence to its imperfect provisions. It is incumbent on those only who accept of great charges to risk themselves on great occasion when the safety of the nation or some of its very high interests are at stake. An officer is bound to obey orders, yet he would be a bad one who should do it in the case for which they were not intended, and which involved the most important consequences. The line of discrimination between cases may be difficult, but the good officer is bound to draw it at his own peril and throw himself on the justice of his country and the rectitude of his motives. So what we got going on with President Trump. He's taking and throwing his whole personage to work towards exercising the proper authorities of his office. And that letter is referenced there from Thomas Jefferson to John B. Colvin. That was in 20 September 1810. What I have to really look at, and what we're going to get to in a bit, is what is happening from the actual notes that were taken during the Constitutional Convention. What was important in that, in particular, was the fact that they wanted a separate and energetic president that would faithfully carry out the laws, and the laws in their full intention in respect to the Constitution. And that's where Jefferson was trying to determine that and speak to that in the segments of the letter that I just read you, was that you have to understand the foundational intent. And to that point, I don't believe that these judges, I know they're called leftist judges, but these judges that are acting in a manner to promote lawfare and their own agendas, their ideologies, and the ideologies of those who are resisting our Republican constitutional form of governance. The laws are clear, and the authority of the president is very clear. We're going to get into that in the other segments, but as I promised you in this last segment, there's a link there to the article from the Gateway Pundit I found this morning. As it's revealed, Chief Justice John Roberts caught in elitist club of judges and lawyers that include James Bosberg, Beryl Howell, Amit Mehta, and Ketia Brown Jackson. These are the leftist judges that are acting against President Trump and his agenda. Now, you're going to have to go determine for yourself what is in that article that I just titled for you. And you need to determine for yourself the deeper investigation of what has been going on with Chief Justice Roberts. People, conservatives in particular, asking the questions, what is going on? How come Roberts made that decision? Where did that come from? He's supposed to be a conservative. It's interesting to at least investigate why there is a secret organization that is there, and why is the Chief Justice a part of it? Come on back. Ladies and gentlemen, welcome back to the Echo Chamber. And I just wanted to follow up with you on the Inn of Courts, which in that group that Chief Justice Roberts is a part of are the founding members, happen to be the 4 notorious judges that are acting against President Trump. Now, I wanted to make clear for you was that when you go look up and on the website of innofcourts.org here in America, that the America Inner Courts is an association of lawyers, judges, and other legal professionals from all levels and backgrounds who share a passion for the professional excellence. Through regular meetings, members are able to build and strengthen professional relationships, discuss fundamental concerns about professionalism and pressing legal issues of the day, share experience and advice, exhort the utmost passion and dedication for the law, providing mentoring opportunities, and advancing the highest levels of integrity, ethics, and civility. Our inns have gained a national and international reputation as an organization that bridges the gap between formal law school education and legal practice by offering career-long continuing education in the common law tradition. So I wanted to stop there because as I consider the 4 primaries that are a part of that particular organization there in D.C., and if we look at the Bossberg, we look at Katanya Brown Johnson as Bossberg is president, Jackson's vice president, treasurer is an attorney, the secretary is another judge from the District of Columbia, program chair is an attorney, membership chair is an attorney, members are listed elsewise. Now, when you take and you try and understand then based on the definition in the national organization, one would try and look at it and go, wait a second, well, what are they doing now that it's a bridge, the gap from the formal education to that which is offering mentorship, offering what is going on with legal practices, exhortation, advice. And when they talk about building reputations and developing the careers and offering career-long continuing education in the common law, we're not seeing the common law in action when it comes to how these judges are looking at the efforts there with none other than President Trump. Where's common law in that regards? And how is common law? And I've done a program on this before where common law in relationship to constitutional law, how do they overlap and what has precedent? In one regard, what was happening with Jefferson's letter that I already quoted to you, that was taking into the assumption of common law as the greater duty in relationship to law when you save the nation, when it is purposed in the direction of the people, the citizenry, especially in the way that our republic is constituted. Remember, the aspect of democracy, which is flagrantly used, the aspect of democracy is minimal and only in relationship to basic voting. It is not the mechanism by which our government states or local function. We function as republics, individual republics constituted together into a greater republic. And as we look at that, and I want you to go, I'm giving you the references here for American Inn of Courts and Wikipedia's and the British Inn of Courts. And, that's what I said in the last segment is you need to go take a look at it. You need to do your own homework. And your whole view may come down to that this is all innocuous. It doesn't really mean anything that Roberts is a part of it. We don't know. But we need to take and understand where this membership is divided into pupillage teams and how does that function. So I think just from a common citizen's perspective, it would be very interesting to delve in and get that broader view of what it means. Now, there is a lot in the article that I've referenced for you that you need to take a look at as well. So I'm letting you do the homework. I'm not doing the homework for you on this. But the point that I really want to drive home is that the presidency has a lot of power given to it. And that power that is given to it is definitely that which was argued very heavily during the Constitutional Convention. And much was written to qualify what it was all about in the execution of it. There were just a lot of references that were made, a lot of views written, a lot of commentaries composed, to which I'm going to bring out one here from William Rawle, A View of the Constitution of the United States from 1829. And it just begins like this, is that in addition to the power over the Army, Navy, and militia, already noticed, the president has a qualified power of appointing the executive and judicial officers. Okay? The former of these are held during his pleasure. So all the executive appointees are held at his pleasure. The latter during good behavior. In respect to both, the commissions are granted by the president, but they specify that it is and by with the advice and consent of the Senate. It was deemed expedient and the approbation of the Senate should be given unless a vacancy happens during its recess, in which case commissions are granted which expire at the end of the next session. It may, however, be questioned whether this restraint on the power of the president fully corresponds with the confidence which is otherwise reposed in him, whether it does not, in some degree, affect the responsibility to public opinion, which would accompany an unlimited power of appointments. You got to let that sink in. And is the Senate taking and tempering the president's choices and activity? If it were left entirely to himself to select such agents as he might deem qualified for public duties, he would, of course, be scrupulous in his choice. But if a Senate, either actuated by party motives or for want of information of fitness of the individual, rejects the nomination, not only may the public interest suffer in the immediate case, but the president be impelled to inadequate substitution. It is true that the converse of this position may also be admitted. Improper nominations proceeding from personal or party influence may be properly rejected by a virtuous and inflexible Senate. That's a big question. We don't have necessarily a virtuous Senate. And I'm going to talk about that a little bit more in the next segment, because we can look at, and I've done another program on the religious background of Congress, and boy, that's a whole aspect of a virtuous and inflexible Senate. Continuing, but in the latter case, if it ever should be our misfortune to have a man so attuted in possession of this high office, we may see him immediately after the rising of the Senate dismiss the incumbent, or in the case of their rejecting one nomination, withholding another and availing himself of the power to appoint during recess. It would therefore appear upon the whole that with the possibility of an evasion which would render the constitutional provision so entirely negatory, it would have been more beneficial to have left this power in the president without restraint, and the more so as the consent of the Senate, here it is not required for the dismission of the officer. This is a very historical perspective in defining that authority of the president in appointees. Even those that were appointed by a different president, a sitting president has every right to dismiss the officer or officers within the bureaucracy without the consent of the Senate, or also without the judges getting involved. So he goes on, the text is not very explicit in the officers' appointments required to the consent of the Senate. It enumerates all the ambassadors and the judges and so on. He goes on to this. So a proper selection and appointment of subordinate officers, those further down, is one of the strongest marks of a powerful mind. It is a duty of the president to acquire as far as possible the intimate knowledge of the capacities and character of his fellow citizens, to disregard the importunities of friends, the hints or menaces of enemies, the bias of party, and the hope of popularity. The latter is sometimes the refuge of feeble-minded men, but its gleam is transient if it is obtained by the direction of honest duty and sound discretion. Popular favor is best secured by carefully asserting and strictly pursuing the true interests of the people. The president himself is elected on the supposition that he is the most capable citizen to understand and promote those interests in every appointment. He ought to consider himself as executing a public trust of the same nature. Ladies and gentlemen, these documents, this particular one that is from William Rawle, on his views of the Constitution and in respect to what does it mean of the powers of the president in appointments, but also to get rid of people. And the clarity there that I want to mention is that if he was going to do the job, who's the best person that he would put into place to do the job as if it was himself? In business, that's what you want to do in your subordinates. You want to hire that best person that is able to carry out what it is that's going to allow you to exercise the vision of your company. More so, here with the president, is that he is elected, as stated with Donald Trump, with a mandate of the populace vote included, to the extent that he has been speaking for years of what is mindful of we the people, and understanding what are the truths in relationship to exercising constitutionalism in a republic. Whereas these judges, I doubt, by their actions, have never taken the time to read all of these fundamental documents as in the Founders' Constitution. Ladies and gentlemen, as we continue to understand what does it mean to be elected as the chief executive, there was a great debate over selecting the form of executive and executive powers functionality in the long run during the Constitutional Convention. As many of you who may have studied this issue will understand that there was proposals for a 3-person group to be co-executives as presidents, a council. There was the idea of never having elections other than one time, except getting rid of the president if he did something wrong. There were limits to 3 years or 7 years. There were questions and arguments about the eligibility of someone taking and being allowed to run for another term. A lot of argument, discussion, proposals, votes, just back and forth on what the executive should be, what they should function as, what their powers ultimately would be, and how do you get rid of them? What is impeachment? What is impeachment in relationship to judges? What is impeachment in relationship to the executive? It was very, very interesting if you take the time to read it. It's quite extensive in this question as to what is an executive, and even to the fact of how is it that they nominate judges to the judicial branch. Why would they do that? What does that mean to be able to make those types of nominations? And then why does the Senate have to get their sticky fingers involved in the executive branch with this consent on who the executive takes and puts into his cabinet? You know, what's up with that? But remember, there was nothing there during those conventions taking away or even discussing that the executive has the power, without question, to dismiss those persons who he initially brings into appointments within his government. Now, I don't want to obviously go through all of this, but I do think that there were some very important motions that were put on the table, especially in, I'm not going to get into how the president was elected, because really in a long-term discussion, what happened was that initially just the state legislatures or the legislature itself would be the ones to take and choose the president. And instead, they were able to come up with this mechanism from a satisfying the popular vote perspective in choosing electors at the state level, so giving that citizen participation, and I guess some people want to call it the Democrat participation, democratic under democracy idea of the people being involved, but at a greater perspective, looking at then how those electors would come together. But you have to remember, we didn't have all the media out there, so the people that were being brought forward for presidents were not always well known by all the citizenry. So therefore, the mechanism of election is something that is needing to be understood. And does it need to be changed? No, not at all. It just needs to be left alone. And to that, we need to understand how we take and manage everything else that's going on within our republic. I don't want to spend a lot of time here. I was going to take you through some of the arguments that Gouverneur Morris was making in relationship to all of this, but instead I thought it'd be more interesting. I want to draw you back again to what William Rawls was discussing in a view of the Constitution, and this is, I think, in section 3435 or pages 3435, 147, and the different sections again in 1829. And where he's going is with the legislative body possesses a great advantage over that of those countries where it may be adjourned or dissolved at the pleasure of the executive authority. It is self-moving and self-dependent. That's our Congress. And it may be convened by the executive. It cannot be adjourned or dissolved by it. So the time of its assembly is fixed by the Constitution, until which, unless the law has been passed appointing an earlier day, or the President on extraordinary occasions has thought proper to convenient, the action of the legislature cannot commence, but if, in their opinion, the public good shall require it. So we have Congress in session for almost forever, and then when they take a break, most people say that's when we're the safest, is when they're not there. The point of it is that if they do take a break and there's something important that comes up, the president can call them back. And that this is a very interesting principle in how our Congress functions as an independent body. So these are similar principles that prevail in state constitutions, and it's the only place in existence anywhere in the world like this. But without a constitutional limit on its duration, it must be conceded that a power in the legislature to protect its own continuance would be dangerous. Blackstone attributes the misfortunes of Charles I to his having unadvisedly passed an act to continue the Parliament, then in being, till such a time as should please to dissolve it. And that became problematic for him. And this is one proof of many that the much praised Constitution of that country wants the character of certainty. So no act of Congress could prolong the continuance of the legislative beyond the term fixed in the Constitution. Now that's important because when we look at next, he's talking about the formation of a republic, there is perhaps no more difficult than the right constitution of executive authority. The three qualities of promptness, of vigor, and responsibility ought to be combined in it. In the two other branches, more deliberation is necessary, whether to make laws or to expound them. The motion should, in general, be slow and cautious. The acts of either, when constitutionally consummate, are obligatory on those whose duty it is to enforce them. The office of executing the law, or a law, excludes the right to judge of it. And of course, does not require that the executive power should concur in opinion on its utility. When the meaning and intention of the legislature are ascertained and the law itself is constitutional, delay in the execution of it is culpable. That's what we had under the Biden administration, both Obama and Biden, that's why I say Biden, is that they violated the law so many different times and they are culpable. They're criminals in what they do by delaying any execution of the law. So we have this invasion, and that's a big problem that occurred also in defining the law, in just going into the basics of ascertaining the truth of what the legislature intended. And this is a fault of the legislature in modern times, is that the legislature necessarily does not define what they intend in the law. So they leave it up to these bureaucrats to come up with any wild-haired ideas as to what the law meant. And therefore, the bureaucracy is within the executive branch, and it is therefore the responsibility of the executive and all of his appointees to carry out the law if it's constitutional. So the public, which may blame the legislature, requires of the executive officer to carry it into effect. Because to subvert the order of government is one of the greatest evils that can befall it. So when we have laws that define what is illegal, like coming into this country without invitation or through the proper mechanisms, those people are illegal. When we look at the various departments, including State Department, the whole national security environment, all of even the government entity called the Department of Uneducation, well, it's education, and so on and so on. First off, are they really constitutional? So this goes into understanding the full effect here in the Founders' Constitution as to what is constitutional and whether the legislature actually acted in a constitutional manner when the EPA came along, when the Department of Education came along, when a lot of the federal government that is in place is actually destructive to the citizenry. So the citizenry can blame everything they want, but every individual is bound to obey the law, however objectionable it may appear to him. So the executive power is bound not only to obey, but to execute it. So when it comes to all of these court cases, not being an attorney, but being a citizen that would have fallen into the category of General Gates' description to Parliament, is that I am an entertainer in understanding the law because I know it better than most that are even attorneys or judges or politicians. That is the job of a citizen, ladies and gentlemen, is for us to know how our government functions so that we can support our president and ensure that he executes the real law and that he vetoes frivolous law and that he appoints people that will hold to the truths and execute with authority what the law is. This idea of being a nation of laws is a much further and longer conversation, which we don't have time for right now. I would encourage you to take and go and look up the references that I'm providing for you from the Founders' Constitution and a few of the other articles that are attached there. I'm not writing anything long at this time, but I want you to understand that the general principles of the authority and duty of the president, that this president, this 47th president of the United States, is acting in the most constitutional manner for the protection of the republic that we have seen for over 100+ years. I'll see you soon again. Thanks.